I'd like to go ahead and call this meeting to order. This is a meeting of the San Luis Obispo County Flood Control and Water Conservation District, the Water Resources Advisory Committee. My name is Andy Pease. I'm the new chair of this committee. And I'd like to start with determination of a quorum. Would those members who are voting members of the WRAC please raise your hand for a quorum count?
Yep.
Thank you. 17 attending. That does establish quorum. Today's agenda is a special presentation and discussion on groundwater law for the Central Coast. I'd like to start with a statement on behalf of the county by Ray D'Anzo.
Yes, thanks. So the special meeting was scheduled based on a decision of the Water Resources Advisory Committee on November 1st, 2017 to hold a groundwater law forum. Pursuant to the committee bylaws, the role of county staff is limited to serving as secretary to the committee, and all opinions expressed by forum speakers are their own and do not reflect the views or opinions of county or county staff.
Thank you. All right, and with that, I will turn it over to our moderator in the panel. Our moderator today is Linda Chipping, our former chair of the WRAC committee and member for the Coastal San Luis RCD. Thank you, Linda.
Thank you, Andy. The purpose of today's forum is educational and informational only. The WRAC has invited guest speakers with expertise in water law to share with us their interpretations of the Sustainable Groundwater Management Act and California water law in general. A list of questions was developed, which I will pose to them. We have asked our speakers to provide general responses to the questions and to avoid site-specific or fact-specific opinions. Time is allocated at the end for a question and answer period. The views and opinions of our guest speakers is provided for educational and informational purposes only and should not be construed as legal advice or an offer to perform legal services on any subject matter. The WRAC encourages all stakeholders to consult with their own counsel regarding these matters. I'd like to extend a thank you to the WRAC Water Law Forum subcommittee members Andy Pease, Debbie Peterson, and David Chipping, and our WRAC Secretary Ray D'Anzo, County Public Works Staff Engineer, and with also the assistance of Aaron Floyd with the City of San Luis Obispo. Our guest panels today are Nicole Kinsey of the State Water Resources Control Board, Wayne Lemieux of Olivares, Madruga, Lemieux, O'Neill, and Stephanie Hastings of the Brownstein firm. There will be cards distributed to you for the question and answer period at the end of the forum, and those will be distributed, and then you can turn those in at the end when we reach that time. And with that, let me say that we have 5 topics which will be addressed. That's the jurisdiction of the State Water Board, water rights, groundwater management and the Sustainable Groundwater Management Act, adjudication, and the state's role under the Sustainable Groundwater Management Act. And with that, we will begin. And we will start with the jurisdiction of the State Water Board.
Thank you so much. Afternoon. First of all, I want to say thank you to all of you for inviting all of us here and me here on such a beautiful day and a beautiful place. So it's wonderful to be here. My name is Nicole Kinsey. I'm an attorney with the State Water Board. I am the primary staff attorney at our office that works on issues related to the Sustainable Groundwater Management Act. I also work closely with staff in our office as well as staff at the Department of Water Resources. So I'm going to do my best to be a representative of the state in general and both agencies, but that said, I have to give the typical lawyer attorney caveat to say that the views I'm going to express are entirely my own and not necessarily those of the State Water Board, the board members, the governor, anyone else. But I'm going to do my best to try to reflect what it is that the agencies are thinking, because so we can have a really robust discussion about some of these really excellent questions. What is the scope of the State Water Board's jurisdiction over surface water and groundwater? I'm going to go over this very, very briefly and at a fairly high level, but just to get us started and get us thinking about some of these issues. As you may know, California operates under a hybrid system of water rights, including in surface water, both riparian rights and appropriative water rights. And then analogously, in the groundwater system, we have overlying rights and appropriative rights. There are also, of course, prescriptive rights, which I will leave it to my fine colleagues to address. Lucky for me, I don't have to go there right now. The State Water Board's permitting authority extends to surface water, but not to groundwater, not to percolating groundwater. The State Board's permitting authority also does not extend to riparian water rights or to water rights, appropriative water rights that were acquired prior to the effective date of the Water Commission Act, that was December 19th, 1914. So any diversion or use of surface water that commenced after December 19th, 1914, that is not pursuant to a riparian right, requires authorization from the State Water Board through a permit, and that is our general permitting system. But in addition to its permitting authority, the State Water Board has other authorities as well. In particular, the board has the responsibility to prevent wasteful and unreasonable use of water, and that is found in Article 10, Section 2 of the state constitution. It's also codified in the Water Code that the State Water Board has particular responsibilities to enforce against wasteful or unreasonable uses of water or methods of diversion. And this authority applies to all water rights, regardless of whether it's surface water or groundwater, and regardless of the claim of right under which the use is being made. So that's a broader sweep of the State Water Board's authority that is not as limited as its permitting authority. The State Water Board also has significant responsibilities under the public trust and to protect the public trust. Very briefly, and this is not doing the topic justice, but the public trust is the reserved interest of the public in certain types of uses, primarily in-stream uses related to navigation, fishing, recreation, other types of ecological interests, and similar factors. The public trust doctrine holds that no one can acquire a vested property right to divert water in a manner that harms public trust uses where protecting those uses would be feasible. And although the public trust doctrine is directly limited to surface water, so it doesn't directly apply to groundwater, in situations where groundwater is tributary to surface water and can impact those uses, there may be a situation where public trust interests do come into play with respect to groundwater extraction. I also wanted to note significantly that the State Water Board has concurrent jurisdiction over most of these types of water rights administration matters, which means that certain types of disputes can either be brought to the State Water Board in the first instance or brought to a court of law. So the board and the courts exercise jurisdiction to a great extent in an overlapping manner over a lot of these issues having to do with waste and unreasonable use, priority of rights, public trust interests, that kind of thing. And then separate from these water rights administration types of duties are the State Water Board's new authorities that were granted by SGMA, the Sustainable Groundwater Management Act. And those are separate and apart from the board's other responsibilities, although of course they're very much interrelated. And these functions having to do with intervention and enforcement under SGMA, I'll talk about a little bit later, but that is an additional scope in which the board is now just starting to participate and extend its authorities having to do with reporting and then intervention in possibly declaring basins probationary and developing interim plans. The second question that I was asked to address is the difference between underflow and groundwater. And I'll do my best on this one, but I expect we might have some follow-up questions. First of all, California, as you probably know, manages surface water and groundwater under separate regulatory systems. In many respects, these two are treated as if they are not physically interconnected, even though in fact they are. Under the Water Code, subterranean streams, which are water under the surface of the ground that's flowing in a known and definite channel, is treated analogously to surface water. It's treated as if it were surface water and subject to the State Water Board's surface water permitting authority and those types of things. Other types of water under the surface of the ground are typically known as percolating groundwater, is for the most part outside of the jurisdiction of the State Water Board with respect to permitting. But as I mentioned, these waste unreasonable use and possibly public trust authorities could come into play. But in general, are outside of the scope of the board's authority. And I'm going to get back to the term underflow in a minute, so just follow along with me here. There's a 4-part test for subterranean streams. I understand from my expert geologist friends that this is a myth, but nonetheless, it's the 4-part test. A subsurface channel must be present. The channel must have relatively impermeable bed and banks. The course of the channel must be known or capable of being determined, and water is flowing in the channel. Note that this 4-part test doesn't talk about the interconnection of the subterranean stream and surface water, or the groundwater and the surface water. That's not a factor in the test, not directly. So you can have a subterranean stream that has no connection to surface water, or you can have percolating groundwater that is fairly closely interconnected with surface water. So that's not the relevant part in determining a subterranean stream under the water code. My understanding of the term underflow, and that's a term that's not defined in the water code, it really isn't used other than in passing in the water code. But my understanding where I've seen it used in typically historical court opinions, that type of thing, is to refer to the flow of a surface stream that's subterranean and a subterranean stream that's closely interconnected with the surface portion of a stream. So this is really part of the stream that is immediately under the surface. It is probably flowing in a natural channel with bed and banks type under the surface. And so it would be a type of subterranean stream. And this underflow would be considered a common source for purposes of water rights. So those surface water riparian rights, the rights to the underflow, they would be all shared correlatively. They would be in common in rights to the same source. And same with the appropriative water rights would operate in terms of priority. So that's my understanding of how underflow is typically used. Like I said, it's not a defined term, so it can be used in different ways, and that in that way is a bit confusing. But I think typically it's meant to be a subset of subterranean streams, and typically is meant to be a situation where you have a common source as between a surface water and this underflow, this subterranean flow that's occurring. And then last, before I'm quiet for a little while, I've been asked, what is the State Water Board's role in permitting groundwater recharge projects? And this has been a big topic that's come up quite a bit lately with the development of GSAs and development of plans, and what are we going to do about overdraft in various basins throughout the state. And also is of interest, particularly last year because of the significant rains that we had and the high flow events, and how are we going to capture those high flow events and put that water into the ground. Groundwater recharge projects that divert surface water to storage underground are generally subject to the State Water Board's permitting authority. An exception to that would be if there's an existing pre-1914 appropriative water right. Those can be changed and used to divert water to underground storage and subsequent beneficial use without a formal approval from the State Water Board, as long as that change doesn't injure any other water users. But typically where we have either an existing permit from the Water Board that's then going to be changed to allow for diversion to underground storage, or a new appropriation of those high flow events to divert to underground storage, that would require a permit from the board. And we're developing processes internally, administratively, to try to streamline those permits. It's something that is very much at the top of the interest pile there at the State Water Board. We're trying to streamline those, set up criteria to make those permits easier to get, set criteria for what is a high flow, where you can capture the peak of those storms in a way that is protective of other water users' interests, and also is protective of any in-stream flow requirements for fish and similar things. There's also a streamlined temporary permit process that we have in place. It can be very quick. We've issued several of these permits in a short turnaround, same season turnaround kind of time frame. The permits are short term, they're temporary, they're meant as an interim measure or something to use while a standard permit is being applied for. But we have had some success in issuing those. They're currently, I think the filing fee is still only $100. They're going cheap. You can look into those. But those are issued for those peak flow events to get that water under the ground. And so far they've worked out pretty well. So I'm going to stop there. I'm happy when we get to the right time to answer questions about it. There's so much more to be said about all of these topics. But I hope that gets us started.
Thank you, Nicole. On to our next topic.
May I just mention one thing as well?
Please.
Hi, Stephanie Hastings from Brownstein High at Farber's WRAC. I'm going to do a ditto on the disclaimer that Nicole provided at the beginning. What we're sharing today are our opinions and don't represent our clients or certainly the governor or anyone else. I just wanted to add one thing to Nicole's excellent discussion about the scope of the State Water Board's jurisdiction. I know you're all here today to hear about groundwater, and traditionally, and as Nicole has described, the State Water Board does not have permitting jurisdiction over groundwater. And that's really one of the fundamental aspects that makes the SIGMA rubric the way it is. There was a significant interest by stakeholders in the state that groundwater regulation that was going to happen in SIGMA would happen at the local level by these new public agencies called groundwater sustainability agencies. You'll hear us talk about them as GSAs. I know you're all well familiar with them. While the state does have a very important role in the implementation of SIGMA, and especially if local agencies are not pulling their weight and not implementing SIGMA, initially, the burden is on local agencies, local stakeholders to implement SIGMA. And I just wanted to point that out. It was a really important driver in the development of the legislation for SIGMA. As probably most of you know, while we've had comprehensive surface water and subterranean water jurisdictions since 1914, groundwater has largely been unregulated until the implementation or adoption of SIGMA. So now we have, 100 years later, a whole new regulatory scheme that applies to groundwater, but again, distinct and different from the regulation that the state has over surface water. So I just wanted to add that additional point.
No? Well, we're ready to move on to water rights, and Wayne will kick off with that.
I'm going to put my disclaimer a little differently. If I were giving you legal advice, I'd have to charge you. Anybody? Okay, so this is a law school class, or maybe we're out at Poly talking about agricultural management or agricultural administration. So we're friendly here. The three of us are capable of taking sharp positions, but we're trying to give you kind of the average position so you understand where the problems may arise. My first question, we received questions from the committee, a lot of questions, and a lot of them were stated differently, but they were the same questions, so we kind of reshuffled them, gathered them into basic groups. And my first question first request is to describe the basic kinds of groundwater rights. So that's what I'm going to do. Now, most of you are farmers, so the groundwater right that's near and dear to you is the overlying right, which is the right of a property owner to pump water from a basin under the property owner's land for use on the land. There's a couple things. It's got to stack up. The water's got to be under your land, and you're using it on your land. The next most common right, I suppose, in terms of contest is the appropriative right. And that's the right of somebody to pump water from a basin who's not an overlying owner. And that can arise in a couple of ways. One is you're a property owner but not overlying the basin. One is you're a property owner overlying the basin, but you're not using the water on your land over the basin. There's a lot of combinations there. The next kind of right, the basic right, or the one that's most often talked about, is a prescriptive right. An appropriator has the right to pump water that is surplus to the needs of the overlying owner. we'll talk about how you decide surplus in a few minutes. So if the appropriator is pumping water that's not surplus to the needs of the overlying owner, that can't be an appropriative right, can it? It has to be something else, and it's considered an adverse right. It's if you drive a truck across your neighbor's property every day for 5 years, you've acquired an adverse right by adverse possession to continue to drive your truck across the property. So a prescriptive right is what accrues when an appropriator is pumping in excess of surplus water for 5 continuous years. Now there's an interesting thing about that. I said 5 continuous years, so if you pump an acre foot, 2 acre feet, 3 acre feet, 4 acre feet, 5 acre feet, how big is the prescriptive right? Anybody? 1, right. You've only pumped 1 for 5 continuous years. Now there are other rights that are important in some places, but not others. In the Antelope Valley, where there's the Edwards Air Force Base covering half a league, whatever that is, the Federal Reserve rights are very important. The federal government has a right to pump water for use on federal lands. It gets kind of exotic, and I don't think in the Central Coast it's going to come up very often in basins that are going to get managed, so I'm just going to skip over that. Another right that's kind of cool to talk about that is probably not going to come here is a Pueblo right. When Pueblos were established before California was a territory and then a state, and those Pueblos had a right, perhaps, well, arguably had a right under Mexican law, and before that under Spanish law, although that's probably not true. The courts have said that's true. Those rights continue to inure to the Pueblos. The Pueblos were cities, San Francisco, Los Angeles, San Diego. There have been half a dozen places that were adjudicated with Pueblo rights. We all look at those. Is Paso a Pueblo? I don't know. Maybe it is. It always comes up when you're litigating that there's other Pueblo rights, but I don't think we need to discuss them too much further. They're very contentious. The other kind of a right that is really not a right to native water per se is return flows, and I'll talk about that in a minute, but those are the major rights. But I'd like to say one significant thing about these rights. They were all created by judicial decree. None of them were created by statute. It was a court saying this is the way it ought to be. And sometimes it's a mistake to believe that those judicial decrees were based on English common law or anything that you would expect. The very first water rights case was Eddy versus Simpson, or Simpson versus Eddy, or it was probably both. 1850, so right after one of the very first volumes of the Supreme Court reports, and it articulated what later became the appropriative rights doctrine. And about 50 years later, the courts were saying, well, as you know, we borrowed the appropriative rights doctrine from Hispanic law or Mexican law and blah, blah, blah. They go on with that. As a matter of fact, that very first case was based on either Germanic mining law or Welsh mining law. So the sources of these groundwater rights are varied. They're all judicial. I didn't mention the public trust, but you handled that already. They're all judicial, and because of that, they are not burdened with the careful and reasoned analysis that legislature goes through when you adopt legislation. Or they're not benefited by it. Maybe I should have said benefit instead of burden. So remember that we're talking about court-made law, and when you have questions about these things, you can't just say, let's go to section so-and-so of the water code and answer the question. You have to go into the cases, and it's quite an ordeal sometimes.
May I add one more?
Yeah.
So you alluded to the developed water right.
Right, and I'll talk more about it in a second.
Okay.
Now, my second raft of questions are, what are correlative rights? What is reasonable beneficial use? What is prescription? What is historical use? A correlative right is a right peculiar to overlying owners. If all of the overlying owners pump exactly the amount of water that's in the basin, then there's no correlative right. But if they pump more than the water that's in the basin, when they're mining the basin, that's not an easy thing to determine, then in theory, they're supposed to each reduce their pumping a correlative amount. There's a lot of argument goes on what is correlative. Does that mean everybody reduces by 10% or everybody reduces by an acre foot or everybody? You can argue about that. I believe the best reading is that everybody reduces by an equal percentage. We already talked about prescription right, how it's calculated and how it is acquired. Reasonable beneficial use, you always see those 4 words together. They come out of the Constitution. And reasonable use and beneficial use, it means 2 different things sometimes. Sometimes it just means the same thing. The state adopted regulations during the drought that irrigating highway medians was an unreasonable use. But I think they could have said it was not a beneficial use to use water for landscape irrigation. There's a case where they're both kind of the same. If you're growing a crop and you use water for frost protection, the state has said that's an unreasonable use. So you see, it's a little different. It's a beneficial use to use water for crop frost protection. But it's not a reasonable use to use flood irrigation. So reasonable beneficial uses are a little bit different. Most of the time they get jammed up and just both mean reasonable. What is historic use? This I want to spend a little bit of time on. The historic use has, we haven't discussed it much here, but I don't think any of the lawyers have a firm understanding what historic use is because it's not a term defined in the law. From that standpoint, you'd say, well, it can't be important, right? Actually, I think it's the most important term that we have, and yet it's not defined, or ill-defined is a better way of putting it. We're not here because the basin has excess water. We're here because the basin has too little water, and somebody's going to have to cut back. How are you going to cut back? How are you going to decide who cuts back? Well, here's the problem. Farmer Joe has used perfect irrigation practices and already reduced consumption by 30%. Farmer Jane has used wasteful irrigation practices and is already using 30% more than she needs. Cut them back both 30%, that's not fair to the person that already reduced, and it gives the person who overproduced a bonus. So what you try to do is you go in there and you try to look at what the historical use has been over a reasonable period of time. And then you argue about it, depending on how much is at stake. I'm sure nobody in this room, but some farmers, knowing that a basin's going to be adjudicated, overproduce like hell to get a historic use so that they can say, well, I'll cut back 30%. It just brings it back to what you really need. But the whole question of what is waste and unreasonable use comes back into the historic use picture. And there's a problem here that it's kind of insurmountable in the case of farming. It's not insurmountable in the case of urban uses. With an urban use, you can construct with skill and daring and a big enough computer, you can decide how much water an average household ought to use. And you can create a system of conservation that says if you use more than what you're supposed to use, we're going to charge you more. And if you think we've miscalculated that, come in and talk to us. That's exactly what some of our clients have done. But I don't think you can do that with agricultural uses because last year you were growing strawberries and this year you're growing rice. So zero-based budgeting for agricultural use is very difficult. You kind of fall back on historic use. Well, how do you apply this historic use? You go into a room. This room is big enough for a basin of 1,000 pumpers. You go in a room and you argue about it. And you talk about it, and you talk about it, and you know what's said is, I'm representing 10,000 acres of farmland. You better listen to me. and I'm only representing 10 acres of farmland, but what I'm saying is so correct, you better listen to me. And you just argue it out. So historical use, what the hell does it mean? It means what you say it means how you settle this thing up. Now, what does that mean in terms of this larger picture of litigation and sigma, or not administrative? Well, think about how that works. In the good old days, with an adjudication, you get to the spot where you decide how to cut back, and somebody says, well, let's base it on historical use, and you negotiate it. If somebody wasn't satisfied, they'd go to the judge and holler, and the judge would resolve it. Same thing's going to happen with these GSAs. There's going to be advisory committees and boards, and everything's going to go along, and there's going to be an agreement or there's not. And if there's not an agreement, instead of going to the judge, you're going to go to the board of directors of the GSA. Is that better? Is it not better? Is a jury better than a judge? Depends on the judge, doesn't it? Depends on the jury, too. And that's kind of what you have here. You got a judge and jury situation where in the old days, under the adjudication actions, the judge would decide how to prescribe the cutbacks. And in the new day, in the new era, under the GSA, an administrative tribunal is going to decide how you do the cutbacks. I don't think there's a right answer. I've seen judges do some great things, and judges kind of miss the boat. But that's where we're at today. Historical use is going to mean the same thing in both cases, but it can't tell you what it is in either case. Stephanie wants to say something.
I want to say something about this, yes. I feel like the footnote person.
So all we're going to give you is footnotes.
That's right. Historical use is not a legal term. It doesn't arise in the cases because it doesn't have any legal significance other than as a fact. It's a component of probably a prescriptive right analysis. So if I'm an appropriator, one of these parties that's not exercising an overlying right, let's say I'm city, if I'm pumping out of the basin during a time when there's no surplus water, then I may have established a prescriptive right. The components of the elements of establishing a prescriptive right require that I pumped for at least 5 years. Well, it begs the question, what 5 years? And I think this is really the important part of historical use. One of the things where the courts are really sort of all over the map about this, at least in the prior adjudication circumstances, is that we don't know specifically what 5 years a court will evaluate. There are situations, for example, many of you are probably familiar with the Santa Maria groundwater adjudication, where a court identified specific 5-year periods prior to the initiation of the lawsuit, prior to the court's decision. Sigma requires that no pumping after 2015 can be considered as part of this 5-year baseline. So what 5-year period is a court going to select? This is going to be a really fundamental question that first the GSA has to consider, and secondly, what the court who may be determining water rights is going to have to select. It may be that it's a very long time back at the beginning of the century, the past century. For example, we know that there are overdraft situations in many basins in the state, particularly in the Central Valley, that extended back into the early 1900s. Is it appropriate to select a 5-year period in, let's say, 1950, when many of the pumpers who exist today didn't exist? Maybe their predecessors did, maybe they don't pump today. Is that an equitable result? Alternatively, is it appropriate to select a 5-year period immediately preceding the filing of a lawsuit? It may be, it's not required, but that is a consideration that the courts are going to have to grapple with. And I can tell you that there is no direction from the appellate courts on specifically that issue. There is direction, and I think this informs the discussion, that a court must adhere to California water rights when implementing a physical solution, which is really the product of a groundwater adjudication. It's an equitable resolution of competing demands to a single supply. It's supposed to be consistent with water rights to the extent possible, and it's supposed to implement Article 10, Section 2 of the California Constitution, which requires reasonable and beneficial use. In implementing a physical solution, the courts are directed that they must adhere to water rights, the same water rights that Wayne has described, but never to the extent that it is a ridiculous or unreasonable result. And I suspect that there is going to be a significant amount of discretion, if you will, that's applied by the courts in selecting that 5-year period. Maybe it's a 20-year period, but it's at least a 5-year period. And it may have fundamental differences as it relates to the users in the basin as to whether prescription took place. So that's my thoughts on historical use.
I'm going to footnote Stephanie's footnote. Nicole, don't get any ideas about this. I don't think I disagree with that, but I want to bring it to the next level. I was talking really beyond that. If you have an adjudication, some adjudications have been resolved based on prescriptive rights, overlying rights, prescriptive rights, and appropriative rights. Some of them. I don't think many of them, to tell you the truth. In my experience, what happens is you have a trial, or you have several trials. You have maybe 5 or 6 trials. You get a piece at a time. You decide what the basin is, what's the safe yield of the basin, whether there's overdraft, whether there's been overlying uses, whether there's appropriate use, blah, 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 all the way down the line. And everybody gets a piece of a water right during this process. Now, they all come in the room at the end, and the overlying owner says, I got 1,000 acre-feet of overlying rights. This is Little Red Riding? No, it's the Three Bears. The second one comes in and says, I've got 1,000 acre-feet of appropriative rights. And the third one comes in and says, I've got 1,000 acre-feet of prescriptive rights. And the judge looks at him and said, oh, that's fascinating, but we're going to cut down. Well, my prescriptive rights are prior and paramount. Oh, are you sure about that? No, wait a minute, my overlying rights are prior and paramount. You sure about that? Why don't you guys go out and talk some more? So in the Santa Maria case, for example, we had a 6-month trial on whether an overdraft existed, and then 6 months of negotiation over what is the consequence of that. And not everybody agreed. Some of the parties didn't agree, and they ended up going back to trial again. But the point I was trying to make is that historical use is important when you're settling up the case. And settling an adjudication case, I think, is going to be very similar to what happens when a GSA adopts a management plan. You can hear from everybody. Maybe not quite scientific enough, or maybe it's too scientific. There's going to be some variation on that. But they're going to get down in the weeds and say, all right, you say you need 100 acre-feet to farm your land, but we know you've been over pumping. So, so on like that. So my point is, historical use is going to be, probably won't be unspoken, but it's going to be the true basis for how you start to settle these cases. And I don't think the GSA are going to be any different than the adjudications in that they'll be resolved by settlement mainly, and very seldom will they be resolved by decree and take it or leave it. So my next question is, on my list, is does conservation, I think I've covered the next batch. How does conservation affect water rights? Well, it affects water rights in a couple of different ways. In a technical way, there's a statute in LA County, for example, that says if you take recycled water in lieu of pumping, your pumping rights are not affected thereby, provided you file some notice and things like that. That's a conservation statute, isn't it? There's the global conservation that if you don't pump, there's more water in the basin. That's not a bad thing. That's one of the effects of conservation that we all hope to enjoy. But if you're not pumping and your neighbor is pumping and you're right back where you start from, that's not a good effect on conservation. Now, if you peel back conservation far enough, the casebook law, the case law is you have a right to use water. If you don't use it, you don't have a right to it. And any exception to that that's called a usufructuary right. Any exception to that has to be stated in a statute. And there are several statutes to that effect. And there are enough of them and enough variety that I really don't want to get more than identify the issues with you. When you can conserve because you're taking recycled water. You can conserve because you're taking conserve pumping because you're taking groundwater. You're actually not conserving water, by the way. When you take recycled water instead of pumping, you're still using water. I hate to tell you. It's like carbon transfers, I guess. But so the conservation thing, I'm gonna push aside and say you ought to conserve because it's gonna, in the end, it's gonna be helpful to you. And the legal rights, I think, are complicated enough where I'd have to charge you if I told you any more. What is developed water and who owns it? The developed water is a good term. It says exactly what it means. It's water that wouldn't be there except for the efforts of somebody. Yeah, in Santa Maria, it was decided that if people spend money to improve the safe yield of the Twitchell Reservoir, the people that spend that money will have created water that wasn't otherwise available to the natural supply, and that was called developed water. And therefore, the people that spent the money to improve the yield got the water. Now that was litigated more or less, and that's the theory. I don't want to re-argue the case, but developed water is water that would waste away if you didn't do anything with it. And there's a lot of ways of developing water. Taking water that's tail water and recycling it under some circumstances could be developed water. Capturing a sheet flow that the flood waters that would normally waste can be developed water. I'm using weasel words I can and could be because to some extent, let me use flood water for an example. There's a flood, the water flows. If nobody does anything, most of that water goes in the ground. That's all natural recharge. That's not flood water. If some part of that water will inevitably flow to the ocean, it's not too easy. Well, it's possible in certain parts of this county. The water that would normally flow to the ocean can be captured as developed water. There's a case with flood water, and believe me, it's more complicated than that. And I let my hydrology license lapse, so that's as far as I'm going to go. What is a return flow and who owns it? Well, a return flow is water imported. This is the result of a lawsuit. Remember I said most of these water rights are made up on the spot by the courts, and this one's the famous San Fernando case where the Supreme Court said, if somebody goes through the expense and trouble of building a big old pipeline to import water to an area, out of the area into the area, in this case the city of LA, so we know the wrong side won. If somebody goes through the trouble of spending the money to import the water, they own the water even if they put it in the ground. Now that's not return flow, they just put it in the ground. The return flow arises in a weird case. City of Glendale pumped water from the ground, served it to their customers, and claimed the right to that water after it was served to their customers and went back into the basin. And the court said, wait a minute, time out. LA brought the water in, put it in the basin. You pumped it out, but LA didn't lose title to the water. That water gets back in the basin. When it's back in the basin, it's return flow, and LA owns it again. So that's what return flow is. And it can be something other than that. Those are the two cases that brought it out. Part of the problem with return flow is you don't put a gallon of water in the basin and have a gallon of water available to pump. And you don't pump a gallon of water and have a gallon of water flow back into the basin after you're done using it. There's losses all around. And in some places, you can't even get the water to percolate if you're in the wrong spot, or it percolates in the wrong direction, or it becomes a surface flow. So return flow is part of the negotiations that go on when managing a basin, but it's not obvious. It exists, you should know about it, it's significant, 20, 30%, maybe, depending on the situation. Can be some nice percentages, but it depends on how much water is imported. What is water banking? Bank of America. Water banking is when you put water in a basin. I'm going to define it myself. And so I can understand, if I define it myself, I can understand it, right? By definition. When you put water in the basin that's not normally in the basin, you're putting water in the bank. None of us put money in the bank without the expectation of taking the money out. So water banking is putting water in, taking water out. It's complicated. It's complicated for the reasons I said a moment ago. When you put water in the basin, on purpose or by accident, it doesn't all go in. So if you put a gallon in, you're not going to bank a gallon. You're going to bank, depending on the geology, you may be banking a half a gallon, or you may be banking something else. And when you put it in, you have to put it in places that are safe. If you put water in the ground in an area, for example, that's contaminated, you could push the contamination around to areas that are not contaminated. So you got to decide where the banking can occur. You don't want to put the water in the ground so rapidly as to cause problems in the root zone with flooding. Some of what you grow can't stand that. You don't want to take it out so fast that you cause subsidence. You want the water to be of a quality that doesn't contaminate the basin. And that's not maybe quite as easy as it sounds. And we all know we don't want to put in trichloroethylene, but contaminations can occur with salts that are benign in one area and not so benign in another area. So water banking is a nice subject. It often results in the water level of the basin increasing, therefore the cost of pumping decreasing. But the final little aspect of water banking that's very important and has to be regulated is you don't want to allow someone to bring water in from outside and fill the basin that's empty because of a long drought, and then watch the native water supply come into the basin and flow right on out. So the normal rule in water banking is that banked water floats. If the basin can fill up with native supply, the bank water is gone. But with all these footnotes and caveats aside, water banking can be very helpful. It can keep your basin full. Quite often, these banking rules, this is something GSA would do, will say the water can only be taken out if the water level is above such and can only be put in if the water level is below such and such. So it can be a good program. You got to watch it. It can be a bad program too. But water banking it's more controversial than it needs to be. Who owns flood water? We talked about that. Can groundwater rights be sold or transferred or exported? Well, yes and no. If you have an adjudication, the adjudication will deal with the subject. Usually in an adjudication, there will be somebody who manages the basin, frequently called a sanioro or water master, and not a ditch master. And the water master will be given powers on how to oversee transfers. You need to oversee it because if you start off with 10 acre feet and I start off with 5, and we're both limited to pumping our rights, and I pump 10, the water master's got to know that I bought 5 from you to make sure the book's balanced. So the water master will be more of a repository of data on transfers. Typically in the adjudication, the transfers are allowed to be freely made because it's really hard to pump exactly your rights. You're going to pump more, you're going to pump less. Some years you're going to fallow the land, some years you're not. So transfers are commonly approved under governed circumstances. I assume the GSAs will do the same thing, that there will be rules for transfer. On export, the typical adjudication prohibits export. It's not quite as simple as that. If your 10,000 acres are 5 in one basin and 5 in another, and you're pumping in one basin and irrigating in both, are you exporting, or is it part of the watershed? Or it's got to apply a little judgment here. Nothing quite as clear as it is when you're arguing about it after over a glass of Glenlivet. But nonetheless, water exporting is generally prohibited by adjudications, and I assume that'd be generally prohibited by GSAs. It seems to be a good idea. Otherwise, how do you manage? You got to make a balance somehow. How do you manage that if you don't know where the water supply is turning over? This county, there was an ordinance circulating for a bit on prohibiting export of water and other things. Several counties have ordinances prohibiting the export of water, not the other things, but just straight export ordinances. The courts have upheld those. We decided that it would be probably another half hour of discussion if we wanted to decide whether cities and counties still have that power after after a GSA is in place and adopts some rules. And since it's not necessary to resolve, and I've reached 2 hours, 54 minutes past the hour, and it's my time to stop talking, I'll stop talking. Thank you.
Linda, may I supplement on that?
Please do.
Okay. The last two questions that Wayne answered related to groundwater banking and exports, or what might also be described as transfers. And Wayne indicated that there's some beneficial aspects of these management techniques, if you will, and I'd just like to underscore that. I have been working in groundwater for a long time, and one of the difficulties that we have had is being able to implement groundwater management programs and techniques that really can augment a basin's yield and provide flexibility for users. And one of the very significant benefits that comes with SGMA, I know the folks come to SGMA with the expectation that it's all bad. There's actually some really great aspects of it, and these two I think are one of them. When there is the type of management construct that is developed by a groundwater sustainability agency, when there's a plan with robust monitoring and measuring and accounting for all of the types of issues that you described, it frees up the availability to implement some of these really interesting and I think beneficial groundwater management techniques. Groundwater banking is a component of what we call conjunctive use, especially in critically overdrafted basins in the state. We need to be able to take advantage of conjunctive use. We need to be able to move waters, surface waters, when they are in surplus, when we have heavy flood type wet years. We need to be able to have a place to put this water. I believe that SGMA, either just through a plan or ultimately through any adjudication, will allow for those accounting measures to be put into place to facilitate conjunctive use of a basin, which can have benefits for all of the users in the basin, not just the parties who are bringing in that additional supply. Additionally, if there is a need for cutbacks because there's an inadequate native water supply, being able to move additional or supplemental water supplies into the basin can have tremendous benefits. It raises water levels. It provides for that additional supply when needed. And it really, goes a long way to redressing the undesirable results that are associated with critically overdrafted basins. And the same goes with water transfers. I take a different position. I don't think that water transfers are necessarily a bad thing. Yes, it is true that some cities and counties, counties predominantly, have adopted groundwater export prohibitions. A GSA under SGMA also has the power to prohibit exports. But I would encourage groundwater sustainability agencies and stakeholders in basins to look at the facts specific to your basin and consider whether there might be some benefits to transfers and possibly even out of basin transfers. The more that we allow a basin to be managed in a way that we can keep track of the molecules, we can respect water rights, but we can augment supplies through some of these groundwater management techniques and market mechanisms, I think will go a long way to achieving the sustainability that Sigma requires.
Can I footnote her footnote? I'll
Sure.
be quick.
1 minute, Wayne.
Because I was imprecise. When I said transfer a few minutes ago, I was referring to interbasin transfers from one neighbor to the next neighbor. When I discussed exports, I was referring to transfers out of the basin. My prejudice is interbasin transfers and water banking, I believe, usually works fine. It's really a good thing. Extra transfers, exports are my prejudice is they're not such a good thing, and you got to prove it before you allow it to happen. So inside, you got to prove it in order to stop it. Going outside, you have to prove it in order to do it. That's a subtle difference. I'm not saying they can't be good in both cases. That's just my prejudice.
And I can see that
I'm not
Nicole.
going to footnote your footnote, though. I just wanted very briefly to reiterate Stephanie's point about, I also agree entirely with the role of GSAs in developing accounting and the importance of that. And just to say from the state board's perspective, when we're looking at these conjunctive use projects, one of the factors that we're considering in how to streamline our permitting process, where you have surface water that's subject to an existing board permit, is to import whatever accounting structure the GSAs may have developed. So where we have an accounting for the basin that's already in place, that's robust, someone is measuring, reporting, keeping track, bring that into our existing permit. That's going to streamline the process immensely, and then also make sure that all the water is being accounted for in a way that is compatible and makes sense. So I'm really hopeful that this will be a efficiency feature that will come out of the development of these management programs under Sigma.
Thank you. And we'll move right along to our next topic, which is groundwater management and the Sustainable Groundwater Management Act. And Stephanie, question number 1. What is Sigma, and does it apply to all groundwater basins?
You know, we've been talking now for an hour about the fundamental thing that we were supposed to define probably in the first minute. So let me just go back for a minute. The Sustainable Groundwater Management Act does, by its terms, apply to all percolating groundwater in the state. It has specific requirements for what we call priority basins. Those are basins that have been designated by the Department of Water Resources, a division of the state, as requiring management. They are medium priority and high priority basins. Those types of basins must have a groundwater sustainability agency and must have a groundwater sustainability plan. Other basins, however, they're still subject to Sigma, but they're not required to do all these things that most of us talk about. They may voluntarily adopt a plan or undertake other management techniques, and I think the jury's out as to whether there will be, probably after the priority basins go first and satisfy their deadlines, whether there will be interest by other basins that are not required to develop plans to do so. So again, I think it is important to understand that Sigma applies to all basins.
Can a county, a city, or water districts override the GSA? For example, can the county adopt an ordinance that prohibits new wells or groundwater exports?
So we've talked about groundwater exports a little bit and answered that question. Yes, the courts have clarified, confirmed that under a county's police power, the counties can implement ordinances that manage groundwater. The relationship between the city or county, both entities have police powers, and the GSA is a very interesting one. They have similar powers as it relates to Sigma. For example, it is entirely possible, and I know of several counties that are considering groundwater well extraction moratoriums, requiring that landowners, or prohibiting landowners from drilling new wells, possibly, for example, until a groundwater management plan is developed. The county, in that case, is undertaking that power. It's police exercise of the police power. SGMA provides that a GSA may do the exact same thing. It says right in the statute, SGMA agency may prohibit the extraction of water from the basin. So what is the intersection? Counties oftentimes are going to be members of the GSA. So from a practical perspective, the county may say, hey, look, we're part of a joint powers authority, which is acting as the GSA. The GSA is going to exercise its powers over groundwater extraction, and we're going to leave this role to the GSA. It's possible that that will occur. It's also possible that the GSA may choose not to prohibit new wells, and that a county may elect to do that. SGMA is very clear that the SGMA powers are in addition to and do not conflict with any powers that an existing public agency already have. You really should think of them as being separate. A county may have a seat on a GSA, but it also doesn't lose its status as a county. It's going to continue to exist as a county. And the same for cities and other public agencies who may have whatever legislative powers they have. Do you have any thoughts on that, Nicole?
No, other than to say it's this concept of concurrent jurisdiction in a way that we're talking about with the State Water Board and the courts, that it is possible to have more than one entity that has authorities over the same subject matter. It can get a little confusing, and it's helpful if those agencies work together. But I agree with your analysis on this point.
I have a slightly different analysis, perhaps. So let me give you a hypothetical rather than speak in the abstract. Suppose a GSA is managing an area and decides that there's excess water to the left and not enough water to the right. So we want the people on the right to pump less and the people on the left to pump more. And the county prohibits pumping in the opposite way. The county wants to prohibit pumping on the right and encourage pumping in the left. Now you've got a conflict between the two. I believe and I hope that the county, cities also are in the same space as the county. Cities and counties and GSAs and water districts and farmers, is it Oklahoma, the farmers and the ranchers can be friends? I think that it was, wasn't it? That everybody works it out and fine, but in the example I just gave you where there's an actual conflict between general government, cities and counties, and the GSA, I believe the GSA prevails.
And that may actually be a term of the contract which the county, likely a participant of the GSA, has signed, or a city. I don't know. That you'd have to examine.
I think it's because of constitutional preemption. But believe me, this has been fun talking about water law, and the three of us can really have a lot of fun talking about constitutional preemption. So can we just agree that it's out there?
Yes, and part of this analysis though is, some public agency may act first, and frankly somebody may complain. And we're going to talk about this at the end of our discussion, but there are a variety of mechanisms whereby stakeholders can challenge whatever action is taken, either by a city or county in this case, or a GSA.
Can you explain what a priority basin is and why it has been designated as that?
I think we already did that one.
Did you do that? I'm sorry.
No, that's all right.
How does safe yield differ from SGMA's undesirable results?
Well, I think I'd pose the question as this: how does safe yield differ from sustainable yield? So safe yield is a legal term that has been developed by the courts through the common law, and it has been used to describe the quantity of water that can be reliably extracted from a basin over a long-term period annually. Now, safe yield, as the courts have defined it, have two important qualifications. When you establish the safe yield, which is really the balance of inflows and outflows from the basin, your baseline for consideration needs to be a long-term historical average. You can't have set the basin during very wet years or during very dry years. So it really has to reflect the long-term hydrology of the basin. The other caveat or addition to the safe yield rule, as the courts describe it, is you have to take into account what is considered as temporary surplus. This is, for those of us who are not hydrogeologists, this is a complicated terminology to understand. But as Wayne says, my definition of it, and the California Supreme Court's definition of it, it's the quantity of water that you can extract in excess of safe yield, but without causing undesirable results. So imagine a groundwater basin where it might not, from a management perspective, be smart to maintain a safe yield balance. You want to allow some room for recharge for wet years. And so that's what the temporary surplus definition really considers. Now, think about sustainable yield. Sustainable yield is the terminology used in SGMA. I think that they are, for all intents and purposes, the same thing. The legislature has taken a little bit more time and effort to go look at the cases and think about, in consultation with hydrogeologists who are experts in this area, a definition that describes the management of the basin in a way that does not result in undesirable results. There's a long list of what are undesirable results in the statute, and lo and behold, those reflect, for the most part, the same undesirable results that the courts have looked at over the years. These are easy. Overdraft, water quality degradation, seawater intrusion, rapidly declining water levels. The one that has gotten the most interest is, and this is Nicole's bailiwick, the intersection between groundwater and surface water. Under the definition in SGMA, sustainable yield, the GSA and ultimately a court must take into consider the effects on adjacent or related surface water supplies. So for example, if I have a critically overdrafted groundwater basin with a river running through it, if pumping in the groundwater basin is adversely affecting surface water or subterranean flows, that is an undesirable result, and it is one of the factors that the GSA must guard against, must establish actions and management techniques to avoid that result.
Can I put on you? I don't think you can say it's always an undesirable result for groundwater pumping to intercept subterranean flows, because if it's water that would waste to the ocean, then that undesirable result is probably a desirable result.
It has to have an adverse impact. In fact, both the case law and the statute say it's got to be a significant and an adverse impact. And again, we talked about this on the telephone. You know, while there is no appellate case that describes this surface water interaction, it's probably because the facts just didn't come up. There's only 20 adjudicated basins in the state of California to date, 22 maybe, I guess, at this point. And it wasn't something that is specifically articulated in those decisions, but frankly, you know, we all were of the opinion that it probably would have been an undesirable result. The fact of the matter is now, under SGMA, it is designated as an undesirable result. The legislature, and I know this because I know that the State Water Board and many of us in the private community participated in drafting of the legislation and providing edits to the legislation. And there was a significant effort, again, by us water lawyers to see if we could reconcile the terminology that the technical community was advocating with the case law. We didn't want to come up with two definitions that weren't going to work together.
Thank you. We've touched on this a bit. But what are GSA's powers, and can Sigma change water rights? You touched on those briefly a little earlier. I'm wondering if there's other things you want to add to that.
So the primary, and we can all talk about this, Sigma does, and this is a very significant portion of the statute, Sigma does articulate many new powers for these new public agencies that are called GSA. The one that we're all familiar with is that they can adopt, they must, in priority basins, adopt a groundwater management plan. But they also have a long list, I'm envisioning 2 pages worth of additional powers, and it is the entire laundry list of things that you can think of that relate to groundwater management. They can require metering and monitoring and space limitations on wells and accounting and what are other types that I'm forgetting?
Charge fees.
Charge fees, yes. Exactly. So those are all the types of powers that a GSA has. And the legislature was clear about this. The point is they wanted to empower these new public agencies to have comprehensive management powers over groundwater, with one exception. This exception is so clear that it sort of boggles my mind that people still talk about it. I think last time I counted like at least a dozen different locations in the Sigma statute. It says Sigma does not adjudicate water rights and does not modify water rights. It's very important limitation. Now, I think this is the $64,000 question, and we could probably spend a whole day talking about it. Do you guys want to jump in here?
Well, yeah, okay. You want me to throw the firebomb?
Sure.
I don't think it matters if you have a water right. Sigma can adopt a management plan and say everybody shall reduce pumping by 5%. And you come in and say, but I have a water right. And Sigma says, we have a management plan. We want everybody to reduce pumping by 5%. So Sigma doesn't have to determine water rights in order to create a management plan. Your water rights are still valid, and you can still assert them, and it'll be taken in. Sigma has the groundwater sustainability agencies have to take your rights into consideration, but it doesn't mean that you've got the winning hand. It means you've got a hand. You've been dealt 5 cards, and it's a 5-card game.
This is how I think this is going to play out. Our expectation is that if a public agency says to a landowner, you are prohibited from drilling a new well, or you are required to cut back by 10%, that a landowner who asserts a senior priority overlying right is going to say, well, I don't care that your document says that it doesn't impact my water rights. It de facto impacts my water rights, and I don't like that. So, and again, we're going to talk about.
I don't think it says it can't impact your water rights. It says you can't abridge your water rights. And I don't think you're abridging the water rights if you simply reduce the amount of pumping everybody equally. And it's really complicated because, for example, I'm going to be half right on this. In the Paso Basin, you have some cities that are arguably have prior prescriptive rights. Just say arguably, help my hypothetical get over with. And then you have a bunch of farmers. If the cities stop pumping altogether, they'll have the effect of, 10% of reduction of irrigation?
I don't know.
Yeah, it's very much leveraged. The cities, I think Paso pumps like 25,000, and there's 100,000 farming pumping, irrigation pumps, something like that. So you can see if everybody cuts back 1%, the city's not doing anything. So it's not going to fix the situation. So even though the city might claim to have a prescriptive right that's prior and paramount to the overlying right, it might be that the GSA has to say, wait a minute, you're going to have to cut back 20% for it to make a difference, and that's fair. And the farmers are going to have to cut back 5% because that's a hell of a lot more water. That screws with the water rights quite a bit, but in terms of a management plan, it manages the basin. And to me, the bellwether for Sigma and the GSA, they've got to manage the basin. They've got to get it done. And if that means they treat overline and prescriptive rights a little differently, then courts haven't treated them much differently than that either, by the way. When you get down to adjudications, they have physical solutions that are very creative.
And that's exactly, I think, the point. If a GSA develops a plan, which includes allocation of other management techniques that a landowner may believe adversely impact their water right, they're less than what they otherwise thought they would have pumped. Then they have to make the decision, well, do I challenge that decision? Then you have to consider, well, what's my likelihood of succeeding in court, but you have to consider what is the measure of your water right. We've talked about, there typically has not been a method for, there's not a method for describing an overlying water right. It's not, I get 25 acre feet. I just have a correlative share with everybody else who's pumping right now. And layered upon that is the premise that all water rights must be reasonable and beneficial in compliance with Article 10, Section 2. If we have an overdrafted groundwater basin and there's not enough water for all of the overlying owners, it's possible that all of the overlying owners only have a correlative share of their share is less than what they're pumping today. And I think that's the point that what Wayne's making is you have to measure the water right based on the reasonableness. And reasonableness takes into account the sustainable yield of the basin. So this is sort of cyclical. If you're on the receiving end of groundwater management or regulatory prohibitions on your water right, then you're going to have to go through this analysis. Is the likelihood that in your hypothetical, the 5% reduction that I'm going to receive from the GSA probably the same thing I'm going to receive from a court? And if so, I know that I retain my overlying right, and I may have no incentive to litigate my water rights because it's probably the physical solution that a court would have come up with anyway. On the other hand, and in fact we have the first test case has been filed last week in Ventura County. A group of landowners are concerned that the allocation plan that has been put in place, or that is at least being talked about, it's not even adopted yet, is not consistent with their water rights, and that it is so far away from consistent with their water rights that the GSA has exceeded their authority. So that's the bookend. In that case, landowners are going to say, Sigma says that it doesn't adjudicate my water rights, and my water rights can't be abridged, and I believe that this plan exceeds the authority of the GSA, and so I'm going to object to the plan. So it really is, there's some practical considerations into, having an internal discussion about what you think your water right is, and what you think it would look like after litigation, if that would be necessary.
And if I can just add briefly, I think I agree with both Stephanie and Wayne on this point, and it's, I think another way to phrase it, and we'll see if I get any footnotes, but is that Sigma does not require a GSA to go through an adjudication, a mini adjudication of its own. That's not as what is required. The GSA has some discretion to come up with a solution, something like a physical solution based on the basin background, the science available, the data available, but it's not required to go through this lengthy process and sometimes very expensive and painful process to get to a solution that is approximately right. So that the intent of the statute is to give GSAs that authority and the leeway to set up a system to achieve sustainability, get within that sustainable yield amount without having to go through the adjudication water right by water right process.
Because the result might be the same in the end, maybe.
Can groundwater be managed by pumpers themselves, and can a GSA have pumpers on its governing board?
So the requirements of SGMA are imposed on the GSA. So it's the public agency, which is the GSA, that is going to manage the basin. That said, technically, they are the manager. That said, there are many provisions in SGMA that make available stakeholder participation. There's very significant notice and hearing requirements. There are requirements that the GSA allow for committees of stakeholders who can provide their input into the development of the plan. So while technically an individual pumper will be subject to the management of the GSA, there are ways to be involved, if you will, in the process. And some pumpers may choose to be involved in more significant ways than others. And one of those ways to be significantly involved would be to be part of the GSA. It is possible for a private landowner to be part of a GSA and not necessarily in their capacity, for example, as a city council person who just happens to own a farm. It is possible for private landowners to be appointed to a GSA, and in fact that has happened. In the Salinas basins, you'll see that agricultural interests have seats at the table and are members of the GSA. So there's examples of that throughout the state. There has been some concern, and us lawyers have debated this issue significantly, especially about a year ago, whether those private pumper seats needed to be selected by or appointed by a public agency, or whether they could sit individually and without any appointment by a public agency. I think the practical result, and where most public agencies have come out on this issue, is that there is some layer of public agency appointment. Some of these situations have far more discretion than others, but for the most part, I don't know of any exceptions where a private landowner sits on a GSA board where there's not some designation or appointment by a public agency. Okay, wow. Check a box.
How would a groundwater basin be managed if only a portion of it were in overdraft?
A basin is an overdraft or it's not an overdraft. If the entire basin is not an overdraft, then you're talking about what we refer to as a pumping hole. And that's a much easier problem to deal with. That's the case where, for example, it could be managed by prohibiting pumping in the hole and encouraging pumping where there's always a high spot to go with low spots. But the courts have said that a basin, you don't know if a basin's overdrafted unless you consider the entire basin. And if the entire basin is overdrafted, it is, and if it's not, it's not.
And sub-basin areas?
Now, maybe you're referring to sub-basin.
Yes.
Yeah. In the Antelope Valley case, there was an argument made that a significant part of the Antelope Valley is huge. The significant part of the Antelope Valley was a sub-basin. And what the evidence was that underneath the ground at about, let's say 200 feet, but I could be off by 100 feet, there was a semi-permeable layer of rock. That water was, from the upper basin, was cascading over this basin of this rock into this lower basin. So it seemed like there was two separate basins. But the evidence also was there was some water flowing through it. And the court found there was enough water flowing through the subterranean dam that the basins were interconnected enough, and actually it was probably the other way around. There was enough interconnection so that pumping from one affected the other, that they would be treated as a single basin. So sub-basin is an interesting concept, but at least as one judge in two different cases found that subterranean flows were enough to make what appeared to be a basin and a sub-basin exactly just one big basin.
I think that the key to this analysis is that Sigma requires groundwater management for the smallest basin described by DWR. Oftentimes that includes many sub-basins. So if you look at DWR's priority list, you may see a parent basin, if you will, with multiple sub-basins. If those sub-basins are identified, they are, quote, basins for purposes of Sigma, and they have to be managed as a unit. There's a lot of requirements in Sigma that ensure that the entire basin is managed. So you can't just manage an area. So if we were to imagine a bathtub, our favorite groundwater basin example, if only one portion of the bathtub has a pumping hole, as you say, you cannot independently manage the pumping hole absent the basin that is described by DWR.
And maybe on this point, just to add some nuance in the context of probation, so, and I'll talk about that in a minute, but in a situation where the State Water Board has come into the basin and is considering whether to declare the basin probationary, either because the basin has failed to develop a plan for the entire basin or is not implementing the plan in such a way that it's likely to achieve sustainability, the board will consider where there's any areas of the basin that does have a plan in place and is implementing that plan in a way that would achieve sustainability. So if you had two GSAs, you might imagine in a basin, one is essentially doing its job and the other is not. That portion of the basin that is doing its job may be accepted from the probationary designation. So there is that nuance in the board's exercise of its authority, where it's in recognition that where local control is working, we're going to leave that be, and the board will focus on that portion of the basin that needs to catch up with the other piece of that.
Okay, the last question that we'll be using, or we'll address the groundwater management and Sigma, is what information about groundwater use will be available to the public, and how will potential conflicts on privacy versus information needed for basin management be resolved?
I represent landowners and agricultural interests, and I know that this issue is extremely important to my clients. Unfortunately, there's really very little guidance in Sigma on this issue. The issue is one of the application of the Public Records Act as opposed to Sigma. Sigma does require the production of a lot of information. We talked about all of those long list of powers. Landowners, any pumper in a basin is going to be required to produce a lot of information about their water use. And it's possible that in doing so, the groundwater user may believe that some of that information is proprietary or protected by our trade secret laws. The way to evaluate the potential disclosure of that information has not changed with the implementation of Sigma. Same rules that would apply absent Sigma apply. There are a lot of exceptions within the Public Records Act that prohibit a public agency or allow an agency not to disclose certain types of records. So trade secret information, for example, crop yields, crop production information is explicitly exempt from production. And this is a little awkward the way this arises. I'm a groundwater user. I'm reporting my water use to the GSA. The GSA then holds that information because they're going to be developing these, accounts of all of this information. And then a third party makes a request to the GSA and says, I want all the information you have on groundwater. What is the information that GSA is going to be required to produce? And that is, again, the lawyers who represent the GSA are going to open up their Public Records Act, and they're going to identify whether any of those exceptions apply. And I suspect that in this case, several of the exceptions will apply. I mentioned the trade secret exception. There's also an exception for geophysical information, which at least one court has found covers groundwater well information. And then there's a catch-all provision that also is included in the Public Records Act for information that does not advance the public interest. It's a very loosey-goosey exception, and I can guarantee you there will be litigation over the extent to which that exceptions apply. I know probably all the city attorneys in the room have seen this before, but that's the framework in which this discussion is going to be had.
By the way, if you litigate, there's nothing undiscoverable. Everything, I'll put it in an affirmative way, everything can be discovered if you're litigating.
Well, my partners who are trade secret lawyers will disagree with you, but okay.
I'll get the data.
Thank you. And we will move on now to the topic of adjudication. Does an adjudicated basin have to comply with SGMA?
A basin that is identified in the SGMA statute as formerly adjudicated, one of those 22 basins that I referred to previously, is expressly exempt from application of SGMA. Now, the problem has arisen in that there are many adjudicated basins where the boundaries of the adjudicated basin don't match the boundaries that DWR has established for the same basin. So those issues are working themselves out right now. You may be in one of those areas. What are we calling these areas? Fringe, yes, fringe areas. So there will be efforts to, for example, adopt alternative plans. The deadline for that has already passed, but some fringe areas are using the alternative plan mechanism to kind of get themselves incorporated into the prior adjudication. You could amend the prior adjudication, or I think there's also GSAs who are being established for the fringe areas. I know that we're involved in a couple of these. I think this is one of these things where I'm going to get in trouble here because probably we have folks in the room that are in a fringe area, but
We are fringe people.
right? I'm sure that this is very disconcerting, but I don't want this to sort of swallow the rule. For the most part, adjudications are going to be exempt, and where this is important at the end of this process is that if a group of landowners, stakeholders, decides to adjudicate a basin in the future, while there are some very specific mechanisms for coordination with the GSA, the State Water Board will not declare an adjudicated basin to be out of compliance, probationary. I forgot the word.
What is a comprehensive or streamlined groundwater adjudication?
As a result of the fact that many of us, and Wayne and I worked in the Santa Maria groundwater basin, pulled our hair out for decades over the inefficiency of comprehensive groundwater litigation. There's been many efforts over the years to try to streamline this process. Thankfully, post-SGMA, there is what we call follow-on legislation that has established mechanisms to streamline the adjudication process. And if you have ever been through an adjudication before and then you compare your experience to what is in the streamlined adjudication statute, I hope that you will find that many of the bad things that happen are going to be streamlined, as we say. The purpose of streamlining is to make more efficient, make quicker, make less expensive, and to get to sustainable groundwater management more effectively than those prior adjudication experiences. Wow.
Okay. And then how do future adjudications tie into SGMA? And does SGMA limit what a judge can do in an adjudication?
Yes, no, this is as a result of the fact that SGMA now exists and did not in the prior adjudications. There are very important intersections, both procedurally and substantively, between a streamlined adjudication and what the GSA is doing with regard to its implementation of SGMA. So from a procedural perspective, the court must be coordinating the process of adjudication with what's going on with SGMA implementation. These are separate processes, but not entirely. There's many places where the court needs to monitor what's going on in the SGMA process, and in fact has to receive information from DWR about what's going on in the SGMA process. So those are some of the procedural intersections. And then substantively, and this is a really important one, the court cannot adopt a judgment which adjudicates a groundwater basin if that judgment would result in a finding or an impairment of sustainable groundwater management. The effect of this is, the message we should all take home, you can't use litigation to avoid SGMA. The statute expressly provides that the court must make a finding that it's not interfering with sustainable groundwater management. So that is an important intersection. The streamlined adjudication statute or comprehensive adjudication statute has some great features, which I referred to earlier, these procedural steps which will hopefully expedite the process. One of those is actually the ability of the court to stay the litigation while the GSA is preparing its plan. Now, that window is pretty short. Initially, it's only a 1-year stay, but it can be extended if the court finds for good cause, and good cause would include the fact that, for example, there's very good progress being made on the development of a plan. If you step back from all of this, the idea is that the GSA is really supposed to be developing the technical framework of what ultimately we would describe as a physical solution. If the GSA is doing all the hard technical work that usually takes a court 10, 20 years to develop with expert witnesses and lots of discovery, the court has a significant interest in letting that technical record be developed, and then it may look to that record as it undertakes its analysis of water rights. Now, this is where the two separate. As I said emphatically previously, SGMA does not adjudicate water rights, but a court may. When a court adjudicates water rights, the court can declare the nature of the right, it can declare the extent of the right, it can say, you have an overlying right, you have an appropriative right, and it can quantify those rights. It can also adopt a physical solution, which, as we talked about previously, is a mechanism that respects water rights, but also allows for competing demands to be represented in some sort of a solution. Again, how do we make sure that folks that have been pumping during this historical period are represented in some form in the ultimate solution for the basin?
Let me suggest a practical advantage too, the way the two act together. One of the difficult things in any adjudication is to acquire basic hydrological sense of the basin. What does it say field? It's a short way of saying that. But everybody starts off trying to agree on a single expert to undertake the very expensive study that's involved at that. Usually in an adjudication, there's not agreement. Every bunches of parties hire experts. They all go off in their different directions. They kind of agree, but not always. And then they come back and you have the battle of the experts. The GSA is an opportunity, and each one of those parties has paid a lot of money for these experts. The GSA is an opportunity to have a kind of an outside expert come in and gather the data, make the safe yield study, and everybody pays for it. Everybody in the GSA pays for it equally and at the same time. And then that common study gets back in the court. Now, the court doesn't have to take it, but if everybody's paid for it and everybody had a stake in it, there's a better than even chance, I think, that the adjudication will be more efficient as a result of that. And instead of having 4 experts with 4 dozen depositions, you have an expert that's been fought over at the GSA level walks in the court and the court says, yep, looks good to me. So there's an opportunity to really speed up the court process with a GSA study.
And also the adjudication statute requires basic, what we would call discovery information as a component of the initial phase of the case. I think that that will go a long way also in expediting these processes. One of the great things about the streamlined adjudication process is that it significantly encourages what we call stipulated judgments. So if there is a need, for whatever reason, for a declaration of water rights, and a large group of pumpers, more than 50% of the parties with interest in the basin, and more than 75% of the production, if that group of parties can get together, develop a physical solution, it may be have its underpinnings in whatever the GSA is doing, and in fact the GSA may be a party to this group. If that group can get together and say, hey, we've got a solution, we want to bring it forward to the court, contrary to what has happened in prior adjudications where a very small number of landowners have been able to hold up a stipulated judgment, this shifts the burden from the proposing and stipulating parties to the objecting parties. And I think that will be pretty significant. Basically, there's some benefit to coming as a group and saying, look, we all agree to this stipulated plan.
Great. We have two more questions, which Nicole will be addressing under the state roles under SGMA. But with time marching on toward the 4 o'clock hour and a need for our question and answer period, I'm going to ask, rather than pass out cards, we're going to have you alternate and come speak at the mic. If you would like to go ahead and line up on either side, and we'll alternate from that. And then we'll have Nicole go ahead and answer a couple questions. We will have the option to extend our time as we get within a couple minutes of 4 o'clock, and the chair will ask for a motion for that. Okay, so Nicole.
Sure, and I'll just go over this very briefly because I think the focus is not as much on state intervention. It's the hope that we can avoid it. But just very briefly, the relative roles of the Department of Water Resources and the State Water Board under SGMA. The Department of Water Resources is the first line regulatory agency. Their role is to review the plans that come in. They've developed regulations that you're probably aware of for purposes of reviewing those plans. What's required to be in a sustainable groundwater management plan? What are they looking for when they review those plans and determine whether or not it's adequate? And then they also have roles, very importantly, related to technical support and funding to assist GSAs in getting to where they need to get to develop these plans, understanding their basin, that type of thing. And then the State Water Board has the role of the enforcer. It's the board's role to step in if there's two mechanisms for intervention. One, if there is a lack of a groundwater sustainability agency, lack of coverage such that pumpers are in a basin but are not within the jurisdictional boundary of a groundwater sustainability agency, those pumpers are required to report their extractions to the State Water Board. And one benefit of that is then we start gathering that data that might be necessary for the next step for the development of a plan, so that time isn't lost while the local agencies may be working out how to address those areas. The second factor is probationary status. The board can designate a basin probationary, a portion of a basin probationary if necessary, and take the steps necessary to develop an interim plan that will be in place until the local agencies can regain control and sustainably manage that basin. And then corresponding with that, of course, is fees that would be required from groundwater extractors to support the costs of developing that interim plan. I think that just an important comment in intersection with Stephanie's discussion about adjudications is that the board can take these steps in terms of probation while a basin is in adjudication. Those processes can occur simultaneously. The one doesn't necessarily stop the other. So it could be, as Wayne talked about, the GSA has an opportunity to identify a technical consultant who might be developing the basin background and this necessary baseline information for adjudication. It's possible that it will end up in certain situations to be the State Water Board. If the board comes in and declares a basin probationary and then is the one to develop that baseline information and charge fees accordingly to do that. So that's another factor that's out there in considering whether an adjudication is the right way to go. Just keeping in mind that the SGMA deadlines and the SGMA processes will be occurring simultaneously. That said, I think it's worth emphasis, the State Water Board is not going to be intervening in every basin. Certainly we don't want to be, we don't have the resources. It's not the idea at all. So there is a big element of prioritization. So these, for example, fringe areas where there's an adjudication and then a few number of pumpers in a fringe area, these are not going to be at the top of the State Water Board's list. I mean, to be frank, if there's not a GSA that's there covering those areas, reporting will be required. But it's unlikely that the board would be looking at those areas for probationary status. That's probably not going to be a priority at that point. So those are just a couple of high items I wanted to hit on before we get to questions, and I think I'm ready to stop at that.
All right, we can go ahead and start with the question and answer period. So if you would like to start at this mic over here.
Thank you. If SGMA affects, here we go. If SGMA affects all groundwater basins, obviously we know what a groundwater basin is. Does it affect groundwater and possibilities for managing or resolving disputes in groundwater that is simply in fractured rock pockets? Has there been any change in our ability to resolve issues there? Thank you.
Who's going to take this one?
I can try. And maybe my fine colleagues will correct me, but my understanding is that as the basins have been designated in DWR's Bulletin 118, those basins extend all the way down. So you may have aquifers that are stacked and you may have bedrock layers, but the way the basins are defined in the statute, the basin goes all the way down as far as any alluvial layers may be there, including pockets that would be in bedrock. That's my understanding. Do you understand differently?
Well, I think that the question
Turn
is
on
a
your
good
mic,
one.
please.
The question's a good one, and I can't look to any specific case law for guidance on this. So it may be one of those things which is outstanding. You know, there are situations factually where fractured bedrock may be technically outside of the basin. And even if it's not percolating groundwater. And so it begs the question whether the SGMA management provisions would apply to it as well. So again, very factually specific and no guidance on this issue.
Next.
Wait, you don't get to ask questions.
This has been very informative, especially as a water lawyer. It's always good to just hear a good, consistent reading of my own sense of how the California water law works, given how we're in a pretty historic period of transition with the SGMA. And likewise, my question is more focused on in-stream flow and the protection of the southern steelhead, which its range is from the San Diego north, here in SLO, Santa Barbara, Ventura. We're seeing some Wildlife Conservation Board is an agency of the state of California that has money under the water bond for projects that enhance stream flow. And here in many of our coastal systems, we have alluvium and these complex interactions between ground and surface flow. And I would ask any of you to sort of share your informal thoughts, if any, on how in-stream flow studies or lack thereof, where a real clear number has or has not yet been set for what the fish need. How do we make real-time determinations within SGMA for these variables related to flow and fish, and the uncertainty that may very well bring to landowners, whether they be public interest organizations or others, who are trying to do the right thing for fish, yet play within the rules of the water rights system.
You get this one
Give it a
first.
shot.
No, I'll sit down.
Thank you for that easy question. There are some watersheds that have been prioritized, as Tom knows, under the California Water Action Plan where Fish and Wildlife and then the State Water Board are considering recommendations of in-stream flows. The Ventura is one of those. And the question has risen is how does that program intersect with SGMA and whatever GSAs may be doing under SGMA? And I think the setting of in-stream flows is going to be one of the factors that ought to be considered by GSAs under that undesirable result number 6. The interconnection of surface water and groundwater is pumping that's occurring, impacting surface water flows in such a way that those flows are dropping below what these minimum in-stream conditions are understood to require. The next question is then what to do about it, and that's not very clear at all. You know, to what extent do water rights priorities play into that? How should that be handled? And that's where the State Water Board and GSAs, I think, will really have to partner and work together to resolve those issues. But in the meantime, in those streams where there are not in-stream flows that are set by Fish and Wildlife or recommended by Fish and Wildlife, where there haven't been in-stream flow conditions set by the State Water Board, it is going to be up to the GSAs to some extent to consider those factors. So it is a challenge. I think that's acknowledged. There are quite a few NGOs out there who are working on developing guidance because it's a challenging issue. Fortunately, there's a little extra time under the SGMA statute before the State Water Board would declare basins probationary on the basis of impacts to surface water flows. But it's one of those things that I really would encourage the GSAs to start thinking about now because it's challenging. What are the impacts to in-stream flows? What are some good ways to set baseline conditions as to how to measure those flows? So it's a good question, one I don't have a good answer for, but it will be a challenge and I think will require hopefully a good partnership with the State Water Board and where we're going, because it really brings in our administration of surface water rights and whether or not the board is doing a good job at that, because that impacts flows more than, in many cases, than groundwater extraction does.
I would just add that I agree with Nicole that this is largely going to be a question of timing. And to the extent that there is, for example, the absence of the intersection with stream flow undesirable result at this point, then a GSA probably has a comfort level that they can go forward without remediating or mitigating for that issue. Again, this is where lawyering crosses over into hydrology, but I would imagine if in the future the State Water Board decides to expand its in-stream flow program to streams and rivers other than the limited number that it presently applies to, that's not going to cause an undesirable result or make worse the conditions that exist today as it relates to the SGMA process. I don't know, maybe that's a technical issue really, but I do agree that it's one of timing. At this point, in-stream flows are mandated only for specified Northern California streams, and unless and until the State Board undertakes that procedural process, which is required to do so in other streams, those requirements don't exist. For everybody who's not familiar with those statutes, there are particular areas in the state in which the State Water Board has required that specified flows be left in stream for the protection of beneficial uses like fish and riparian habitat and those things.
Next question. And David, before you start, I just want to check in with our group here. We're coming up on 4 o'clock. Our panel has offered, if needed, that they could stay a little bit longer. Can I see a show of hands of who still has a question to ask of our panel? Quite a few. And so as we get to 4 o'clock, if people have to leave, we honor your time, and no one will think ill of you if you want to slip out. But otherwise, as far as WRAC members, I'd entertain a motion, if anybody, to extend the time past 4 o'clock as late as no later than 4:30. Is there any move? David Chipping, so moved. Thank you, Tim Walters, for a second. All in favor, please say aye. Aye. Any opposed? All right, so we have until 4:30 as needed. Thank you.
The question has come up in the Central Valley that as crops have gone from row crop to things like pistachio, the ability to manage agricultural land by cutting back irrigation has been made impossible due to the claimed losses of the entire crop for the future. In other words, in the Central Valley, maybe if you've got a problem, you could not plant lettuce for a year in a field, but in a pistachio or vineyard situation, you must keep irrigating or you lose everything. How would that be handled by Sigma?
I agree that that is an issue that the GSAs will have to grapple with. And part of, kind of back to where we started with, this is why it is so important that groundwater management be addressed on a local level, because the factual circumstance that you just described might not exist in a different basin. And so the management techniques that are going to be necessary in your hypothetical example would be different than, for example, here on the Central Coast. That said, if we're talking about, this goes back to our discussion about historical use. That might be one component of the analysis. Another component would be, I would take the position that all overlying owners are correlative, and irrigation and agricultural production is both respected as beneficial uses under the law. There is no preference under the law for one type of agriculture as compared to another. There's going to have to be some creative management techniques that are going to have to take into account that there are agricultural products that can't be easily taken out of production. Fallowing is not a simple example in your case. But again, I don't think that it's necessarily insurmountable. There may need to be, for example, more consideration of the conjunctive use type management techniques we talked about before, trading, allocation, those kinds of things. And there's going to have to be some creative land use planning that's associated with this as well. There is very specific intersections between Sigma and city and county's general planning auspices, and you can see that in the statute. GSA agencies have to talk to cities and counties when they're doing general plans and vice versa, and hopefully that's where some of this discussion is going to happen. But again, very locally specific. I don't have the technical solution for your example, but I don't think that from a water rights perspective, there's no difference between Farmer A and Farmer B in your example.
There's lots of references to measuring, monitoring, reporting, water pumping and use in the GSAs. That can lead to discussions about, does that basically mandate metering of wells? That's can be a very contentious issue. It can be fighting words out in some parts of the country. And so the question is, do you believe maybe it's just opinion at this point, but where do you think water metering fits in the future? Is it a reality you're simply going to have to deal with, or are there going to be other ways to do it, like figuring out how much power you use or something? Is it going to be a fact of life? And number two, if it is, how safe is that information from being attributed to individual people as opposed to, everything can be hacked these days, but let's say for the moment it couldn't be. Would it stay out of the public domain? If so, and how does Sigma handle that?
Right. So as to the first part of the question, Sigma doesn't mandate the methodology, and so actually my response is more of a practical one than a legal one. I think in whatever the location is, folks are going to have to decide whether it's worth the expense to meter every single well. There may be a cheaper solution to get to the exact same piece of information, but ultimately the result is the same. I think the GSA, especially in priority basins, medium and high, and certainly in critically overdrafted basins, is going to have to understand the total outflows from the basin, which include groundwater pumping. And in order to do that, they've got to amalgamate all the individual data. So they very specifically have the power to request groundwater pumping information from all users, landowners, cities, utilities, whomever. And again, the discussion about how they do that, I think is just it's a practical question. What's going to be the cheapest, most reliable method for doing that? I do believe that it is in every pumper's interest to be able to have good and accurate records of your groundwater production, because my opinion is that goes to the analysis of the scope and extent of your water right, when and if that might be necessary. It's the whole historical use piece that we were talking about. Now, you also talked about a little bit the confidentiality of that information. We talked about that previously with regard to the Public Records Act. So to the extent that you're required to produce the information, it's then held by the public agency, it's within their records. And then the analysis that the attorneys for the public agency will undertake is, are we then required to produce it to someone from the public who asks for it? There are pretty good exceptions. In other words, that the GSA does not have to provide all of the information, but I suspect that there's going to be a lot of discussion about this issue. Maybe this is sort of a best management kind of piece of advice, but I would advise GSAs and stakeholders are part of this process to really talk about this issue so that everybody understands what is the bank of information, how is it going to be managed, so that you get a good understanding about how the GSA is going to respond to those Public Record Act requests when they happen.
I'd like to say a couple things on this. Exchanging data is the best way to solve disputes. And so there's a really good reason to exchanging data. And that's the way I felt for 50 years. Then but I'm reminded of what that famous Fresno farmer, Victor Davis Hanson, says, that every government official ought to be prepared to live under the regulations that he adopts. And I now have a well. And I don't want anybody metering my well, and I don't want to register my guns, and there's a lot of other things I don't want to do for no good reason except I don't want to do it. So we understand that metering is a big imposition, and I think most GSAs, because they're made up of your neighbors, are going to understand that too. If you leave it to the courts, they're going to put meters on everything. Or if you leave it to a big enough government, they'll put meters on everything. But you can usually get around it you can get the data that you need to settle disputes without doing that. Hanson's right.
Thank you. I just have a couple questions, and I know we didn't cover de minimis users, so when I talk about metering, I look at de minimis users that aren't part of the problem. In the case in the Paso Basin, they're 3% of the users. So I don't see them as an issue when we're talking about metering everything. But I look at public agencies and wanting to be in charge of stuff, and I wonder, why do you want to put the coyote in charge of the chicken coop? And they're more or less part of the problem. The reason more water is pumped because the state doesn't deliver the water they're supposed to deliver. And in our specific area, this historic use thing, which I see people trying to do, because here just a few weeks ago we had 3 to 5 inches of rain, and there were sprinklers running in the vineyards because they put their own meters on so they could show historic use. And I have a problem with this, and I don't know what the legal panel thinks about that when people come up with documentation like this to show what these people are doing, and they're part of the GSAs. When an agency, or I'm going to use a city, and I'm going to use Paso as an example, they have other sources of water. They have Nacimiento water, and they have Salinas River water. And when their wells are the one that's creating a problem in a certain portion of the basin and the rest of the basin is fine, why aren't they forced to reduce their pumping to see if it alleviates the problem? And then my other question is, we have the Santa Margarita Reservoir, which the river, the Salinas River, it's the headwaters of the river, flows north. And that river is the coronary artery for the basin. Yet, when the dam was built for war reasons, the water was on an unfinished permit is being taken to South County and is damaging the basin. What can be done if that is shown to be part of the problem in the basin? Last question is overdraft. Isn't that something that's issued by the court and not an agency, the term? And the reason I say that is because the State Water Control Board, Thomas Howard, said he had no technical information to state that the basin was in overdraft, that he read some articles in the paper. So I find it amazing there's no technical information, but we could be extremely overdrafted, yet nothing's changed in the last 5 years. Thank you.
I think a lot of your questions are asking for legal advice, and that's gonna cost you $400 an hour.
I got some.
But a couple of the things we can address, and that is the business about is there an overdraft or is there not an overdraft. What I was trying to say earlier is that the GSA can hire experts, and there's a lot of thought has to go into that, and there's gonna be a lot of argument about who the expert is. The expert can examine the basin and offer an opinion as to whether the basin's an overdrafted or not. Now, if there's an adjudication or a companion case, that information is going to get taken over to the courthouse one way or the other. Somebody's going to bring it over there. And everybody in the lawsuit can look at that and say, yeah, that's good enough, we'll go with that. Or they can say no and put on their own, spend their own money for hydrogeology. But I think there's no harm in having a GSA do a hydrological study. It might be right.
No, I agree with you, and I've been involved for the last 5 years, and I've looked at every study from 2000 to present. There's not one summary or conclusion or nothing in the body of any of the reports that were done by all the agencies that were being hired by the county, of this county, that stipulate that we're in overdraft. So I find it amazing that we're in overdraft, but there's not one report that hundreds of thousands of dollars have been spent on, millions of dollars by this county to say that, but nobody can show me the paperwork that proves that.
First of all, thanks to WRAC and our panelists for your time and efforts today. My question is, are there any movements afoot legislatively or through our courts that may have an influence on the principle of the landowner's rights to pump water?
So, interesting, good question. I think I follow pending legislation related to water generally pretty closely, and I can say that there's no legislation that I know of that specifically addresses the nature of the water right, if that's what you're referring to. There are always, and I'm not, maybe you're up on top of this more than I am, there have been efforts to talk about, for example, conservation issues and things like that, but nothing that I'm aware of that talks about the declaration of water rights or changing water rights in any way. That is the auspices of a court. The way we are set up in California with respect to water rights is that there, as Nicole mentioned previously, there's two bodies that have jurisdiction over water rights, and I would suppose that like, for example, just with SGMA, the legislature is going to try to stay out of this domain. I would think there would be a lot of objection if you saw, for example, SGMA 2, where all the provisions that say we're not adjudicating water rights were crossed off, or some other aspect were added. This is really something that is truly the auspices of the court, and the reason for that is because water rights are vested property rights. And in order to modify a vested property right, you have to go through a deliberative process. And that's the kind of process that only the court can do.
Recall what I said earlier, that every type of groundwater right was made by a court, not by statute. And the reason for that is groundwater rights are too controversial to be resolved by legislation.
This area has two functioning operating desal plants. One is a small one on the mesa run by the oil companies that discharges 400 acre feet into the ocean. Right close to that is what's called a pumping depression in the Pomo, and no one's ever used that water to cure the pumping depression. The other is a quite larger desal plant called Diablo Canyon. It presently does 1,000 acre feet, has a capacity for 2,000 acre feet. Nobody seems to look at that. That's extra water, free water. When when Diablo Canyon is shut down, that desal plant is still going to run, and nobody's looking at where that water's going to go. Are you people going to look at it? Nobody in this area has been looking at it. How about the GSA? Are you going to take that into consideration?
Well, just to clarify, I don't represent the GSA specifically. Whatever GSA you're referring to, in that case, it's an adjudicated basin, so it's exempt from SGMA. But so just to clarify about that part, what I think generally, I can't speak to the specific facts that you're describing, but I think generally what you're raising is one of the interesting groundwater management or conjunctive use type opportunities that might exist. Again, I have no background or facts about your particular example. There might be concerns about water quality. I don't know. Nicole talked about the jurisdiction of the State Water Board to permit groundwater replenishment when you're using surface water supplies. All of these kinds of opportunities, let's just say, may receive more critical examination now that a GSA is responsible for sustainably managing a basin under a very tight time frame. Maybe that's the kind of motivation.
I was just curious as to why we're supposedly in a drought and we're allowing people to outflow 400 or 1,400 acre feet of water into the ocean.
There's another desal plant in Cambria. In perhaps the best of worlds, that portion of the county that can be served from desal plants, and there's quite a bit of it, will take water from the desal plants. It's a little more expensive, and that portion of the county which can't take desal water will help them pay for it, and it'll balance out everything. That's what Stephanie was mentioning with conjunctive use.
With the oil company and Diablo Canyon, you got somebody else paying for it.
Oh,
I mean, it's not the idea it's going to
Anybody
cost
here,
you any money.
raise your hand if the oil company ever paid for something for you.
If I can just add a little bit on that point, I think it does bring up this, what we see in Southern California in those basins that have been adjudicated for a long period of time, and we see recycled water that is injected to form the seawater intrusion barriers. And those, I think, are very successful, and the water's treated to standards for drinking water because eventually that water filters back into the drinking water system, but by injecting underground, that itself has some treatment properties, and so it's helpful for treatment in getting to standards. And I think actually that's the result of having basins that have been managed for a long time. They've figured out systems of accounting. Those entities that are injecting water can get credit for it, have made those types of projects possible. So it may be that we'll see more and more of those types of projects.
It really is the mechanism to be able to account for all those molecules, which is I think, a benefit.
Hello, again, thank you for being here and for those who organized this. I hope you brought your crystal ball here with you. Your opinions are going to be necessary on this one. As these GSAs start the process of putting their plans together and try to implement them, especially in the high and medium priority basins, and they include, say, measures like you must have meters, you must report the data, you must cut back on your use, or you must space your wells differently or not put in another one. Many of us who've been working on these local agencies have been wondering how quickly is litigation going to come, and what impact will that litigation have on the GSAs trying to implement their plans. Opinions, obviously, but if there's one in Ventura, are there many more coming? And how, and I guess the second part of the question is, how will the differentiation, as the plans are created uniquely for those local basins and their measures are different one from another, will that complicate things in the courts? Well, they're doing it this way over here, why can't we do that over here, that type of thing. Right. So just a curiosity of what kind of impact this is going to have on the GSAs implementing their plan with litigation coming. Thanks.
It's a great question. I think, again, this is sort of the really important practical and strategic considerations that all stakeholders have to take into account. We talked about this a little bit previously. When a stakeholder is considering whether let's assume that the stakeholder is monitoring the GSA process and the development of the plan. at some point the stakeholder begins to be concerned for whatever reason. Things are just not going well. It looks like there's a lot of regulatory actions in the plan that are not going to be acceptable. At that point, the stakeholder then has to consider, well, what are my options? If there's an individual action that the GSA has taken, so for example, let's say the GSA adopts a fee, or it adopts a well moratorium, then that's a specific action that a stakeholder can challenge. They can bring a writ of mandate under the traditional mandamus proceedings to challenge the individual action. They also have the opportunity to do that after the plan is developed. So that's sort of the wait and see strategy, right? So I'm gonna see how things work out. Maybe this plan's not gonna be so bad. Maybe it's not gonna adversely impact my business operations, right? Because a water right has no significance other than it has a relationship to what you're doing with the land, right? I mean, I need the water right because it allows me to produce the water to farm or do whatever, business operation I have. So let's say the 5% cutback is not meaningful to me from a practical perspective. I might choose not to pursue or challenge in any way that component of the plan or that action. On the other hand, if it's a very significant or material deprivation of my rights, therefore, I'm concerned about whether my business operations are viable, then I'm going to be more interested in challenging the GSA's activities. And there's a couple of different mechanisms for doing that. I mean, we talked about the streamlined adjudication statute. It is also possible, like I mentioned, that you can bring an individual action against a GSA. And this is not something that you would do affirmatively, but there's also a provision in SGMA that allows the GSA to validate their plan. And that's, again, a litigation opportunity where you may say, no, I don't like the plan, and I think that the GSA has exceeded its authority. You would then intervene in that action. So there's a whole host of different places in which litigation may arise. The timing of a comprehensive adjudication, there is no rules for this. It could happen at any time. It could happen today. It could happen in 2020 or 2022 when the plans are developed, or it may not happen for 20 years from now until there is a need for a groundwater adjudication, and it's the water rights component, which is the driver there. SGMA provides the groundwater management. The one piece that it doesn't include is the declaration and allocation of water rights. If you make the determination that you need that component, you need that very high level of certainty that's associated with that declaration of rights, then you bring your litigation in whatever form sooner than later. If you don't need that certainty, if you're willing to live with the plan, knowing that it doesn't modify or alter your water rights, then you may not adjudicate for some long period of time.
Traditionally, important water rights cases are heard by the California Supreme Court. The California Supreme Court doesn't have to hear an appeal from the Court of Appeals. They can deny it, but traditionally they accept hearings on water cases, especially important water cases. I think it's entirely possible that the jurisdictional issues involving a GSA could be resolved in a single case by the California Supreme Court. If somebody is not very careful on how they bring that case and all the issues are presented at the same time, bam, it's over. So that should caution everybody to be careful what lawsuit you appeal. You better be pretty solid on that. And it's never a good idea to litigate because you don't have any control whatsoever.
Well, I disagree. I think that there is I cannot imagine the causes of action and the factual circumstances that would arise that would give rise to a single appellate decision that negated all other litigation in all basins.
No,
Again,
I didn't say that. On the subject of the power of a GSA, I think a single case can resolve that.
Power of the GSA to do what?
To manage a basin. I think a single case could come to the conclusion that the GSA has primary and exclusive jurisdiction to manage basins. I'm not saying it's a right decision or a wrong decision. I'm saying it's possible, if the case is presented inarticulately, that the court will come to that conclusion. And I don't think I'm telling a secret when I say the California Supreme Court often sets water policy more than follows judicial precedent. Well, I said that 3 or 4 times today. So I think it's entirely possible that you could learn what you need to learn about the power of GSA in a single case.
I don't even think you need the litigation for that, because I think you just read the statute. It's pretty darn clear on its face. The GSA has the power to manage groundwater. It has the power to implement very specific regulatory mechanisms. It says right there, may prohibit new wells, period. They definitely have the power.
If I can add to the parade of horribles for the GSA, I also just want to note that there can be lawsuits not only from the water right holders, but from other interest groups. I anticipate there will be lawsuits from environmental groups, environmental interests. On the other side, has the GSA carried out its responsibilities under SGMA in a way that's appropriate? And those may also be interesting, although I likewise think the GSA has quite a bit of discretionary authority to make those decisions, as long as those decisions are documented well. So that's a pitch for documentation. Are these decisions that go into the planning process based on data and based on the policy-making discretion of those GSA decision makers?
Yeah, and Nicole raises a very important point, because although the courts do apply deference to agencies under the traditional writ of mandate procedures, did I say deference to the GSA, the public agency? The decision is bounded on the other side by, it can't be an arbitrary decision. You know, if there's no overdraft, then prohibiting people from pumping or prohibiting new wells seems arbitrary to me. It can't be capricious. It's got to be supported by evidence. So there are bookends, and that's the tension. And so I think what the legislature was looking for was forcing stakeholders to see if they can resolve these tensions on a local basis, individually. I'm sure you are all sitting in public meetings with your GSAs arguing about exactly these issues. You know, to the extent they can't be resolved in the public meetings that are required under SGMA, then they might end up in court. You know, frankly, I don't think that's such a bad thing. If I have a client who needs total certainty over the extent of their water right, they want a number, there's really only one mechanism that I can give them. We need to file a complaint, because that's not going to happen in the context of SGMA.
So the next question will be the last question for the afternoon.
You know, guys, you can't talk longer than us. No matter how much you wish you could. You win.
I also would like to thank you guys for spending the time to do this. It's always good to hear from well-qualified experts. Couldn't quite keep up with the note-taking. But my question is, what role do federal land managers, federal well owners, and state land managers, state water consumers have in the GSA and SGMA process? Thank you.
I think that's best from you, Nicole.
I'm not sure, and maybe clarify for me, are you thinking of federal, when you say federal land, you're federal lands and pumping that occurs on federal lands, and the federal land well owners would be the federal agencies, presumably,
Well,
that
yes,
we're talking about? Okay.
Yeah, I'm obviously connected with one of those agencies. We own some wells, we pump. Sometimes we pump a lot.
Right, right. That is, I think, a really interesting question that I have contemplated but haven't delved into because the intersection of SGMA and federal reserved rights or other types of federally held water rights is really interesting. I'm going to make an off-cuff answer, which is always dangerous, which is, to some extent, federally held water rights, I'm not talking federal reserved, might be subject to limits under SGMA. And there might be situations where you have a pumper on federal lands that would be subject to limits under SGMA. In other situations with federally reserved rights, that pumping may fall outside of the regulatory authority of SGMA, of the GSAs. That said, the pumping needs to be taken into account when the GSAs are developing their plans. So that it would be very useful to the extent possible for federal agencies and the local GSA to share data. I know I've talked quite a bit with representatives from the U.S. Navy, and it seems to me they're doing best efforts to try to work with folks in the basins where they're active to share data, to share in costs, to work together, because of course it's in the interest of the federal agencies to see the sustainable management of the basin as well. But I think there are going to be some interesting jurisdictional questions. It also relates to federally reserved tribal rights in those areas where those are a factor as well. And we just haven't gotten there yet. I mean, there's been so much, but I have seen this as an issue that will come up.
Seems like there's a lot of state federal cases that are being talked about in the news recently.
With that, I'd like to say thank you very much, Nicole, Wayne, and Stephanie, for making time in your busy schedules to come and address our WRAC membership and some of the public at large. We totally appreciate your expertise and the information that you were willing to share with us.
I hazard to say these things are fun, but they are for us water lawyers.
And with that, I'll turn this back over to the chair.
And with that, meeting adjourned until our next regular WRAC meeting, May 2nd, 1:30, and it'll be back in the library community room. Thank you very much to all for attending.